Thanks for inviting me. In a way, I feel a bit of a fraud being here because I'm not a lawyer and my expertise isn't in wildlife law, so you might think, well, what on earth am I doing talking at a conference on wildlife law? It's a good question. I don't have a simple answer for that. But what I'm hoping to be able to give you is sort of a perspective on the UK's wildlife law and whether it's fit for purpose from an NGO perspective. So my name is Mark Jones, I'm a vet. I work for an NGO called Humane International UK. We're part of a large international NGO concerned with animal protection for all kinds of animals. And our mother organisation, if you like, is Humane Society United States. With anybody who knows it, that's a big organisation as far as animal protection NGOs goes. But in the UK, we're tiny. So much of the work that we do is done in collaboration with others through collaborative forums. And I've put two up there which I think are particularly relevant. Wildlife and Countryside Link, which brings together 41, might be more than that, 44 voluntary organisations concerned with the conservation and protection of wildlife in the countryside. Moana Mackenzie from Link is here, and we have a few other Link member organisations represented. And also the Species Survival Network, of which we remember, this is a network of over 100 NGOs dedicated to promoting wildlife protection and conservation through the enhancement and strict enforcement of CITES regulations. And I'll mention CITES in a short while. So, can you go back one?
Yep.
Oh. Okay.
What up the wrong one, do you want me to check?
So, no. Pop forward. Okay, just to go through what I'm going to try and say today. First of all, I'm going to try and ask some simple questions and give you some sort of simple non-lawyer perspectives on answers to these questions. What's wildlife protection legislation for? What's it there to do? What are our current arrangements? Do they achieve the objectives, what we think it's for? And a little bit about some recent advances that we have seen and some possible solutions to some of the problems that we see. So first of all, what's wildlife legislation for? Well, this is a very non-legal perspective. In the end, it's to stop people doing bad things to wildlife and natural habitats. Very simplistic, but sometimes we get into so much sort of legal argument, it's easy to forget what it is we're actually trying to do. And obviously there are times when you do have to do bad things or you do have to intervene. It might be nice to think that we should never interfere with wildlife and natural habitats, but we live in a human-dominated environment where interventions and management are clearly necessary. So the law is or should also be there, in my view, to regulate those activities and interventions that are deemed necessary, usually through some kind of licensing system, in order to try and ensure that the interventions are necessary, proportionate, and the appropriate risk evaluations are undertaken. So, just in a little bit more detail, it's there to protect wildlife habitats and ecosystems, to regulate wildlife use and management, prevent overexploitation, possibly mitigating human-wildlife conflict at times. I've put protect the welfare of sentient wild animals in there. I've popped that in there because I kind of work for a welfare-oriented organisation, and there's not all that much in our current legal framework for wildlife that is really focused on welfare. But it's come up recently in a few instances. And also to ensure that the penalties for harming wildlife and wildlife habitats have suitably dissuasive effects. We're getting outside legislation into penalties, enforcement penalties there. I don't think that you can divorce these things. You've got to think about them together. In terms of our current arrangements, well, we all know this, we have a raft of domestic legislation. We're required to implement various bits of EU legislation. We're also subject to a number of international commitments. I've introduced them with domestic legislation first, sort of going up the pyramid, if you like, deliberately. In some ways, people think about them cascading downwards. We have international commitments, we have EU commitments, and then we implement these through domestic legislation. And that, to some extent, is true, I think. But I've done it that way around because much of our domestic legislation predates EU legislation predates our international commitments, and we're constantly trying to catch up by reviewing or amending existing domestic legislation, and that in itself presents quite a challenge, and I'll talk about that in a moment. Just to outline a few of the bits of legislation and some of the commitments that we're talking about. Our international commitments include membership of a number of international environmental agreements. There are several. Two I'm going to mention here: CITES, which as we know is concerned with international trade in endangered species and the parts or products derived from them. And CITES is interesting because it specifically requires parties to transpose the rules and regulations and decisions and so forth that are made at CITES meetings into their national law. And there are sanctions for not doing this and for breaching CITES rules and regulations. The UK is quite an early signatory to CITES. I think it ratified CITES in 1976. The EU, interestingly, all EU countries are parties. The EU is also now becoming a party in its own right. And there's some debate and uncertainty about how that will affect the existing EU member states and their relationship with CITES and who's going to have competence over what area. So we're in an interesting time as regards CITES. CITES is transposed into EU law via the EU wildlife trade regulations and the UK through the UK's COTES regulations, which I'll mention in a bit. I've put the, sorry, can you go back? I've put the Berne Convention up there. This is the Council of Europe Convention on the Conservation of European Wildlife and Natural Habitats. The UK has been a signatory since '82, and it's largely implemented into English law through Wildlife and Countryside Act 1981. And the main two EU directives, there are many others which impact the environment and wildlife, are the Birds Directive and the Habitats Directive. And then we have our domestic legislation. We have a plethora, as Angus has mentioned, of domestic legislation. I don't think this is an exhaustive list. In fact, Sarah, one of my colleagues there, pointed out that there were several things missing from here. I've tried to put one or two of them in. Anyway, it's not exhaustive. I'm going to come back to that in a moment. So, thanks, Angus.
So it's just on the spot, isn't it?
I'm making work out. So the next question is, do our current arrangements achieve our objectives? Do they actually protect wildlife and restrict our management of wildlife to that which is necessary, proportionate and so forth? Well, that's a tricky question to answer in any simple way, because we have so many different regulations covering so many different things. No doubt some of it works quite well and some of it doesn't. But from a public perspective, a quick trawl through Google will bring up any number of newspaper reports and so forth that illegal activity relating to wildlife and wildlife crime is on the rise. And certainly I would suggest from a public perspective it doesn't suggest that our wildlife and biodiversity regulations are doing a particularly good job of protecting it. And we also, thanks Angus, we also have a number of reports that have come out in recent years, such as the State of Nature report, which was produced by 23 conservation organisations last middle of last year it came out anyway. And things like Nature Check, which is produced by Link, it was most recently published in November last year, which also painted a pretty sorry picture on the state of our wildlife and biodiversity and the way things are moving, suggesting our current arrangements are not doing a particularly good job of protecting it. So why is this? Well, again, difficult question, but to look at why this might be, I think we need to examine the key three elements of wildlife legislation and wildlife protection. That's the legislation itself, the enforcement effort and the arrangements for enforcing legislation, and the penalties. Now, I know we're here to talk about legislation, but I don't think you can divorce these things, because legislation without effective enforcement and persuasive penalties is just a piece of paper and is worth absolutely nothing. If we go back to our domestic legislation, this wonderful slide, if you can, Angus, here, starting with our domestic wildlife legislation, as I described it, plethora of acts and regulations have been variously described as fractured by the House of Commons Environmental Audit Committee, badly in need of consolidation by the Association of Chief Police Officers, and with classic RSPCA and a bit of a mess by the RSPCA. We could go on and on. You can find all kinds of comments on this, but it certainly doesn't appear from these august bodies who have been examining this that they think that our domestic legislation is in a particularly good state. Much of the core legislation has been heavily amended. I mentioned this earlier. We create legislation, then we sort of catch up with international commitments, EU commitments, and we end up with heavily amended legislation which is difficult for non-specialists to understand. This certainly applies to the Wildlife and Countryside Act 1981, which is supposed to implement the Habitats Directive as well as aspects of the Berne Convention, so it's a really important piece of legislation. As Angus said, many pieces of legislation that we have are very species specific and not really related to protection of wider systems. And some species are included and have levels of protection, other species aren't. So there's lots of species missing from our from the raft of legislation that we have. And much of our existing legislation on our statute book is ancient. And of course, when old legislation was introduced, the purpose of the legislation may have been rather different. A lot of legislation which affects wildlife in the UK was actually introduced in order to protect land rights and in order to protect what people could do on their own land, rather than protect the biodiversity on the land per se. And a lot of this legislation is still in the statute, but it's not really relevant to our current situation. I use the example of the Hare Preservation Act of 1982, which bans the sale, but interestingly not the killing of hares for consumption, between March and July. Now this was introduced to give hares some respite from shooting and during their breeding season, and back in the day it may have had some degree of effect, but with changes in the purpose of hare shoots, refrigeration, all these kind of things, it really doesn't offer hares any protection now. And our hare populations effectively lack a close season. And because most of the shoots, for historical reasons, occur at the beginning of the breeding season and take out often 40+% of our hare populations, certainly in eastern England, where they're also relatively abundant, this is a problem. But we're constantly told that the introduction of the closed season would require primary legislation. And there is a lack of parliamentary time, in spite of considerable cross-party support for this. So we're in a sort of catch-22. They're not protected by current legislation. We can't get a closed season on the statute book. In terms of enforcement and priority setting, the Wildlife Crime Conservation Advisory Group present recommendations to UK tasking and coordination groups which set priorities and then are delivered by priority delivery groups. So it's a kind of cascade system. And you can find the current priorities on the National Wildlife Crime Unit website. That's quite a useful resource. But, makes sense? But the Crown Prosecution Service will only prosecute those cases where the police lead the investigation. And for the CPS to take a case forward, the Code for Crown Prosecutors stipulates that cases must pass both an evidential test, i.e. should have a realistic prospect of conviction, and a public interest test, and in a way this is more controversial. You look at the sort of impact on species locally, nationally, internationally, the secondary impacts that interventions may have, levels of public outrage, whether it's, whether the criminal activity is organised, whether there's commercial gain involved and so forth. And with wildlife crime often being seen as soft and victimless, I think this is a problem. So we end up with a situation where the CPS won't take on a lot of these cases. And as I think Keith and Angus both mentioned, much of it is left to NGOs and other agencies with all the problems that comes from that. And if we think about penalties, in terms of penalties, we have a situation where the consequences of contravening wildlife legislation are all too often not dissuasive. I'm going to give you a couple of examples, and this example comes to me courtesy of the Bat Conservation Trust. We have Pete from the Bat Conservation Trust here today, so thanks for this, Pete. This is a case in Bridlington last year of a developer who wanted to knock down 6 houses and these houses contained a number of bat roosts involving brown long-eared bats, whiskered bats and pipistrelle bat roosts. And he destroyed the houses, destroyed the bat roosts. He was prosecuted. He was fined £35 per roost destroyed, total £210. A £20 victim surcharge and £85 costs. Now, the cost of him complying with the law in order to go through the process of removing and relocating those roosts would have been thousands of pounds. So clearly, it's not in his financial interest to comply with the law, because the consequence of his illegal activity is much less costly to him than compliance. So there's a problem. Another example from Wimbledon earlier this year, a guy who was dealing in ivory, whalebone, dolphin bone, marine shell online, an online trader, who ended up being found guilty and fined £250 per count, £750 in total, with a small victim surcharge and some costs. But the value of the products that he was, the illegal value, if you like, of the products he was dealing in, was thousands and thousands and thousands of pounds. So the consequence was nothing like the value to him of the trade. Now, you might say it's easy to come up with a couple of examples to demonstrate that penalties for criminal activity are inadequate, and you could do this for just about any aspect of law enforcement, I'm sure. And you'd probably be right. But I do think these examples do seem to be very typical from what we see and reflect a lack of focus on wildlife crime, which is all too often not seen as a major priority by the relevant bodies, police, CPS, magistrates, judiciary and so on. And this often results in NGOs and other agencies taking on cases, often at high cost, only to see derisory penalties being handed out if those cases are won. So what do we do? Clearly we've got issues here with legislation, enforcement and penalties. But what do we do about it? Well, I think the Environmental Audit Committee inquiry into wildlife crime in 2012 offered some useful pointers, and LINK, we continue to engage through LINK and with our colleagues and partners at LINK with the appropriate government departments and agencies with respect to implementation of the Environmental Audit Committee's recommendations, which included a whole raft of recommendations. I'm not going to go through them now. But some of them were good, and we continue to work closely with agencies to try and persuade them to implement them. And a couple there that are quite interesting. They recommended introducing a vicarious liability for apts poisoning for England and Wales, as it is in Scotland, I believe, and the need to deal with invasive and native species. And this is something that has been taken forward. Now, in terms of international commitments, there has been some progress recently. We had the Illegal Wildlife Trade Summit in London in February 2014. And it was very good to see the UK taking a leading role in the global illegal wildlife trade in recognition of the involvement of organised crime and the serious nature of the trade and the consequences in terms of political instability, funding of terrorist organisations, involvement of organised crime and so forth. And the declaration that came out of that meeting contained some serious commitments by the UK and the other signatories, which we certainly hope to see fulfilled. And there were 46 countries and 11 intergovernmental organisations that took part in that. We also saw some serious, relatively serious money being put forward in order to try and tackle some of the implementation and enforcement issues. So it was really good. In terms of the domestic UK actions that sort of follow on from that international meeting, the next step listed under the sort of getting the UK's own house in order commitments were heavily weighted on international action. And really the only true domestic commitment to come out of that was the securing of 2 years funding for the National Wildlife Crime Unit. Now that's important, but in and of itself it's nowhere near enough. We do also have a legislative commitment for to review the COTES regulations, which implement CITES in the UK for this year. Interestingly, at present, they're not planning on looking at internet trade, which seems really odd because internet online trade is a huge issue and one by which international illegal trade in many products is now conducted. And yet it's not going to form part, as far as we know at the moment, of the consultation process on review of COTES. And that seems to be just way off the mark. It seems to indicate a lack of recognition of where some of this stuff, where some of these problems are occurring. So we're certainly pushing for that. In terms of actions, well, in terms of how seriously departments and agencies are taking wildlife crime, we have seen some useful progress. The Association of Police and Crime Commissioners have decided that they're going to have a lead on wildlife crime, which should be useful in terms of recordability. There are some changes. Norman Baker announced some changes in April of this year that said that wildlife offences would have their own classification. Up to now they haven't been recorded within the counting rules. So that's good. Of course, this only relates to those instances of wildlife crime dealt with by the police. So it is limited and it still doesn't go far enough, and we do desperately need an accessible, centrally held database of crimes and prosecutions, so a baseline of crimes being committed can be established and resources, that baseline used in order to better target resources and capacity. And in terms of prosecutions, the CPS does now have in place 13 wildlife specialist area coordinators, and is now talking about very recently the appointment of a wildlife champion, and that's all good to see, but we still lack good training for general prosecutors on wildlife crime, and we still lack good training for the judiciary. So in terms of sentencing, I think there's still a lot to do, and we would like to see, it's been mentioned today, a presumption of protection for wildlife with the necessary exceptions rather than this mishmash of different protection that we have through our legislation at the moment, and that doesn't seem to be progressing very much. And the issue of vicarious liability, which maybe Keith can talk to with respect to the Law Commission process, but I'm not sure where that's going in that respect. And obviously we've engaged with the Law Commission through the process that they're going through. It's very good to see that process happening. It's very important to us that we don't lose some of the protection that we currently have, complicated and disjointed though it might be, but that we arrive at a point where we have much clearer legislation which people can understand much more easily. And lastly, I just wanted to flag up something that's come out of a think tank called the Centre for Animals and Social Justice. Now, this is related to animal welfare, so it's not quite what we're talking about here, although clearly there's crossover. But in terms of trying to sort of up the importance of wildlife legislation, environmental and biodiversity protection within government departments, they came up with quite an interesting model which you can find online, where they suggested that welfare should have a commissioner or ombudsman within government, that in order to achieve policy integration of welfare issues, it should have ministerial level responsibility in every government department, and much more cross-departmental dialogue in order to make sure that it doesn't just all fall under DEFRA, which is, best will in the world, a rather poorly funded and small and relatively less important government department than some of the others. And again, they were talking about the constitutionalisation of the presumption of protection for welfare, and that's something we'd like to see in some context with regards to wildlife protection. So, we want to stop wildlife legislation being seen as soft, and we certainly want to stop it being seen as victimless. And I hope that's a useful stimulus for some discussion in the show. Thank you very much.
Bang on time as well. Any questions for Mark? Or do you want to just agree with everything he said? Or just let it rest there?
It's easy being the NGO representative of lawyers, because then you just but obviously he doesn't understand that's going away with it.
Not everybody's a lawyer, is they? So yes. And then
It's a question about the wildlife crime being on the rise.
Sorry.
question about wildlife crime being on the rise.
Yes. To what extent is it due to either A, the fact there's so much more legislation now making things offensive, and B, that there's a greater public interest usually in natural history, so people are out there actually seeing the things and then reporting them. So it's about the sort of null hypothesis I'm putting forward. It's a background of wildlife crime which is coming under closer scrutiny rather than an expanded.
Yeah, it's a good question because wildlife crime isn't or hasn't been recordable until recent times. Yeah, but most wildlife crime in certain aspects of that largely relates to international illegal wildlife trade across international borders. But it's hard to know really because we don't have a long data set. I suspect that wildlife crime has always been. Once you introduce legislation, once you introduce the Protection of Badgers Act, you get a sudden massive increase in wildlife crime because people carry on with the activities that were previously not prohibited, that suddenly become prohibited for a period of time. So you will get an increase. But I suspect you're right. There's perhaps in recent years more of an interest, public interest, in seeing and trying to prevent or trying to report wildlife crime. So to some extent it may be a function of effort rather than actual increase in activity. But there might be others, it might be worth talking to someone like Hendon from the National Wildlife Crime Unit or others who might have a better perspective.
Keith,
Actually,
yep.
Pete was about to say something about wildlife crime, seems, but that's specifically this very much.
I was just going to make the point, it's very difficult to assess levels of wildlife crime and to assess the legislation in place. Because nobody has an agreement over what wildlife crime is. And unless we have a definition of wildlife crime, it's very difficult to make these assessments. The list you put up are perfectly understandable reasons doesn't include the hunting. Some people will say that's wildlife crime, others won't. But if it isn't, as is held in, as is the opinion of some, then neither is the Protection of Badgers Act. And I think it is important that, if we're going to have these discussions, there must be clarity over what we mean by wildlife crime.
Yeah, and it's very interesting that I'm not having a go at them because this was the remit they were given, but the Hunting Act was specifically excluded from the Law Commission.
I can say something about it. Maybe I'll go down actually I'll go down and reverse it. I agree entirely about the problem about statistics on wildlife crime. I think the notice of the because we have increasingly use statistics for crime. So, there's something now measured that never was. So suddenly you have numbers which you never did. But the point of, even if you take the list that you took, a wildlife crime could be an action against a habitat, or it could not. Does it have to be a direct or an indirect killing? Which of those will or won't be counted as a habitat crime, if that is something separate, or a wildlife crime? So not all of that which is within Part 1 of the Wildlife and Countryside Act could be considered as a wildlife crime, or could be, depending on how you draw it. So it is absolutely awful to draw up, and that's even before you get to the obstruction offences, which also exist in Part 1 of the Wildlife and Countryside Act. I have two little comments. One is a historical thing. My understanding of the hare, in relation to the Hare Preservation Act, is that the exemption, the limitation on sale was to protect food supplies for the rural poor. So it was actually a progressive sign of the time in a really, really weird way. Interestingly, the Game Act was a widening as opposed to a limitation of the franchise of those people who could take or have a right over wildlife. It's quite, they're quite interesting things. That was the aside. The more specific thing, offences. My understanding is that level 5 crimes are going to disappear and be replaced by unlimited fines. So all wildlife crime will gain unlimited fines as of a date not yet specified. There's a provision which has not been put in force. There is a plan to put it into force that is likely to be this year. Actually, it will be this Parliament, I would any use.
No, it's very interesting to hear. And, we could get into discussion about asset seizure and confidence with respect to this. So,
That doesn't, by the way, solve the other problem, which is that you don't know how people calculate it even against a maximum sentence.
sure.
Okay.
Yes, my question regards the dark side of public interest toward wildlife legislation in the opposition toward EU-led legislation. Where I come from, in my research context, the Nordic countries, people don't comply with regulation because of who it comes from the EU level, because of how it's formulated, because of the normative content of the questions, and also some discrepancies between EU law and Swedish law, for instance. So they're seen as illegitimate and not fair and haven't been arrived at through public participation processes and so on. And I liked your slide of the old poaching acts, for instance, because they, to me, weren't very effective for a multitude of reasons, which that they actually contributed to a lot of poaching, or poaching actually took place parallel to them. And I think that although poaching is a very multifaceted crime, it was in part motivated sociopolitically because the legislating elite who imposed these laws were seen as oppressive and illegitimate in a way that the EU is seen today from the Nordic countries. And I was wondering, in the UK, I know that you're a country that is quite Euroscepticist as well, perhaps more so than the Nordic countries, and I'm surprised that there isn't more skepticism, resistance, and opposition toward the habitat structure and coming down and imposing on your laws.
I think you're right. I think getting into sort of political arenas here, but there's a level of Euroscepticism in the UK. It will be greater or lesser than in other places, depending on where you go, I guess. Seems to have been manifest quite strongly in the recent elections. Let's not go there. Am I right in saying that the UK tends to be quite a stickler for, as a country, for implementing legislation that's imposed on it, if you like, regulations imposed on it quite, obsessively almost, compared to some other countries?
Like France.
No.
Yeah. So, I mean, it might not like the legislation, but it tends to try.
I think you can go further. We will complain vociferously about the legislation, but we'll implement it anyway.
All right.
That's pretty much how it works, I think.
And, you mentioned some of the obvious, because some of these laws may have been relatively effective at the time for the purpose for which they were introduced. The problem is they're lumped in with our wildlife and environmental protection legislation these days, but that may not have been their original purpose. Their original purpose was often to protect people's rights on land, not to protect biodiversity. But they're kind of lumped in with the biodiversity regulation now, and a lot of them still in the statute book.
It's true, yeah. Pete and then Keith?
You say that we will implement the directive, and I agree with you, we do. But having done that, we don't take any steps to enforce it. And I think that's a problem. We've got legislation, but there is no pressure put on anybody to abide by it. So the police don't planners don't discharge their responsibilities. And government seems to take no interest in that. So although we implement the directive in parts, we don't implement the bits that call for strict protection and persuasive penalties. And that's a big problem.
And we particularly through the Link network and other colleagues in other organisations that have much more experience with this than I have, we try to engage with the Crime Prosecution Service. We try and engage with the ACPO, and we try and engage with the judiciary and the magistrates and so on and so forth. And it's really hard to do because, as the very last slide I put up there, before the nice slide of the hair, we don't, wildlife crime is all too often seen as soft and victimless, so it's not on anyone's priority in terms of those organisations. That's where we need to get it. We need to get it on, and there is some encouraging stuff going on through the police and crime commissioners and the identification of sort of wildlife champions within some of these structures. But we need to push that all the time, because I still think it's seen as being very low on most people's priorities.
A quick comment from Keith before we move on.
I'm I don't know whether the statistics would necessarily back up that we are the perfect implementers of European law, but that's not going to be my point here. I think the reason there hasn't been this backtrack against Europe in relation to birds especially, but perhaps in plants, at least a species, is because they're not always seen as EU laws. Prior to the 81 Act, there was a 54 Act. Prior to the 54 Act, there was another Act. There has been a piece of protection of birds legislation since 1881. There was a conservation statute for a lot of the sorts of things which look like they're protected under the Wildlife and Countryside Act and the Conservation of Species Regulations 2010 in a 75 Act. Or in separate other pieces of legislation, which means that you have seals protected in two different ways, but they're not seen as European. Some things are seen as European when it affects planning and things looks like that. So processes, things like planning process, that is seen as European, the EIA type of thing. But actually, I don't think there's that feeling that a lot of this law really is European, and so, you know, it hasn't built that backtrack because it's not a new imposition, which has caused other problems for implementation because we've used the old model as opposed to actually implementing the directive, which is a bit of a problem. But it doesn't have that political sort of build-up of suddenly you've got this new law and therefore let's fight against Europe, because its subject matter isn't, you know.
And that sort of goes back to that pyramid of, if you like, or the concentric circles, or partly overlapping circles between domestic, EU and international commitments. I think it's really important to look at that from the bottom up, because as you say, a lot of our legislation has been in place a long time, and what we end up doing is adjusting or amending our existing legislation in order to try and make ourselves compliant with EU regulations or international commitments. So exactly what you're saying, really. You know, the legislation in some form is already there. So maybe that's
commendable then that the UK has this kind of consistency of laws, that they are seen as compatible with domestic laws. It's a good thing.
I think we've ended up in a mess because we try and amend legislation which doesn't quite fit with, you know, EU regulations or directives or international commitments, and you end up with things like Wildlife and Countryside Act, which is, I'm not a lawyer, but certainly as a non-lawyer it's completely incomprehensible. But I'm sure it was much simpler when it was written in 1999.
Okay, I'm going to move on to our next speaker.